Hi everyone. The reason Yuvi's laughing is because she thinks I look like Tina from what's the show?
Bob's Burgers.
Bob's Burger.
I'm gonna put a picture up right now.
So he's gonna put a picture up, and now we can't talk.
It's also the behavior. I'm sorry. It's
Really?
the classes. They match.
Really? Okay, great. Okay, this is gonna be one of those episodes, folks. Ordinarily, we talk about watches, but clearly,
I don't wear a
you
watch.
don't wear a watch. She just wears plenty of bling. So
Plenty of bling.
we're
I
not
like
going to
that.
talk about watches to start this episode. We're not going to talk about cartoon characters anymore because we have to be serious for a bit.
Right, because we're going to talk about something very, very, very complicated, messed up.
I'd say f***ed up. You can bleep that if you need to. So this is Weinstein 2.0, folks. As I'm sure many of you've heard, the New York Court of Appeal came down with its decision just a week or so ago, where they overturned his 2020 convictions on two felony sex crimes. And the word two is important. We'll get to that shortly. Where they basically found that the lower court made, to quote them, egregious errors. And we're going to kind of focus on those two errors tonight because they're pretty egregious.
Because I've not seen that happen here, at least.
Egregious errors?
No.
In Canada? We have egregious errors.
No, we have egregious errors, but the kind of error that happened is something that I haven't seen.
Okay, so just we'll dive deeper, but the two main errors that the appellate court found were the prosecution strategies that were employed by way of two, I guess they were pre-trial motions. So the first motion was something they call we've been calling it Molinex because we can't pronounce it. Molyneux, if you're French. Molineux, which is a motion, at least in the state of New York, with respect to calling other witnesses, I guess, similar fact.
To testify about offenses that the accused is not charged with.
Right,
They
that's
can
the
provide
bottom line.
evidence in relation to that.
Right. The bottom line is he's not charged with any offenses in relation to those witnesses. In this case, it was women, but that evidence still goes in. And the second motion is called a Sandoval hearing, Sandovl, for what it's worth, where broader, I guess, bad character evidence is requested by the Crown to be admitted against the accused. So it kind of answered our initial question when we were prepping for this episode, why the hell didn't Weinstein testify in his defense? Kind of makes sense now once we dive deeper in what was allowed for at trial and then overruled by the Court of Appeal. Why don't you start with Molyneux? Because you like to say that.
Molyneux.
I don't know.
So what I essentially understood from this application is that the prosecution has to bring an application and get permission from the judge to bring witnesses to testify about offenses that they have allegedly gone through and provide evidence and in relation to offenses that the accused is not charged with. So let's say you're charged with sexual assault with complainant number A. But the Crown is allowed to bring complainant number B, because you're not charged with complainant number B, but she can come in and she can testify about, hey, I was sexually assaulted in this manner. And that is essentially what happened. The prosecution was allowed to, I believe, bring three witnesses.
3 or 4 witnesses
and
that
provide
they
evidence,
lined up.
Provide evidence in relation to what allegedly happened with them.
Right, allegedly, right.
Right, so that is what, I haven't heard of that before. To be honest with you, I haven't heard that happening before.
Here or anywhere?
Anywhere for that matter. I was a little surprised to see this happen.
Well, as Max said as we were preparing, I think everyone got caught up in the emotion of this case and the fact that, it was going to trial, and it was just mind-boggling that these women were allowed to testify about this stuff. And then the second motion, the Sandoval motion. Again, I'm scratching my head. I hope I never get charged with anything in the States, because this was all of Harvey's skeletons were let out of the closet. 28 allegations that they allowed to be used by the prosecution, including physically attacking his brother, threatening to cut off a colleague's genitals with gardening shears, throwing a table of food, screaming and cursing at hotel restaurant staff after they told him the kitchen was closed, and the list goes on. I think there are like probably
25 to 35 instances.
yeah, just to continue, because this was just mind-boggling. Virtually all of his skeletons. He told a woman he could harm her professionally. He filed an application for a passport using a friend's social insurance number.
Yeah.
Falsified a photo for a movie poster by photoshopping a female actor's head on another woman's nude body. It's just like, where does it end? And like, we're not talking about charges. We're just talking about alleged bad crap. Crap
bad
out of his
behavior
closet. And so that all went in. So kind of answered our question when we were scratching our heads. Why didn't Harvey testify? That's kind of self-explanatory.
Well, the reason he did not testify, or rather he was advised not to testify, is because he was going to be cross-examined on these things.
Right.
So the judge allowed
forever
the
and ever.
prosecution.
Yeah.
You need, if you're the Crown Attorney, if you're the prosecution or the Assistant District Attorney in the U.S., you have to get permission from the judge and say, this is what I want to cross-examine the person on, because all of these instances, they are bad acts, they're prior bad acts. They're inadmissible in court, in trial, right? So in order for them to ask you questions about it, you have to seek permission, you have to show why it's relevant, and there's this whole level of explanation and submissions that you have to make as to what is the scope of where I'm going to go with this.
Right.
And the problem in this is with all the areas that was allowed for the prosecution to go in, he can get cross-examined on whether did you withdraw from a business deal and ask others to seize its funding? What does that have to do
Did you
with
threaten
whether or not
Did you threaten to cut some guy's dick off?
No, but what does that have anything to do with whether or not you
sex
sexually
assault
assaulted
allegations?
this
Yeah,
complainant?
I know. That's why this is mind-boggling.
So, yeah, it is mind-boggling.
It is mind-boggling. I just like to say that, and the appellate court succinctly said the threat of a cross-examination highlighting these untested allegations undermined the defendant's right to testify. Who in their right mind would testify?
Not wine.
What?
We're not drinking wine.
No,
Just
unless
water.
Yeah, for now. Like, it was just like, what the hell? No wonder he didn't testify. I think that kind of has answered.
The threat, because you
Right.
as an accused have the right to testify, and when
Yeah, of
you
course.
are being threatened in many ways that we're gonna ask you questions about all these other areas of your life,
Right. Why would
that
you
deters
expose
you
yourself?
from exactly.
And as you were speculating earlier, like, could this result in further charges if he testified? Who knows?
Right, exactly.
Who knows?
You don't know. Go ahead.
Right. No, you go. You finish.
No, you were gonna
I
say
interrupted
something.
you. No,
I don't know, so look, you don't have the privilege of knowing what happened, but what was the discussion between the lawyer and the client, of course not.
Right.
But you can only speculate. And one of the things is that you feel threatened that, okay, they're going to ask me questions about these offenses that I'm not charged with. They're going to ask me these questions about, these bad character evidence.
Oh, you're being judgmental. These acts these skeletons from my closet.
Well, they're, if you say someone that I'm going to chop off your private genitals and stuff, I don't think that's necessarily a good thing about you.
Depends on the situation.
So, yeah, it depends on the situation, right?
Yeah,
correct.
right.
I still don't see how that's a nice thing to say.
Again, depends on the situation. I'm sure we've all said worse.
Right.
Right. So what happens in Canada if a Crown tries this stuff?
Well, number one, the Crown has to bring an application. They have to explain why they want to talk about certain acts from the accused's history that may, for example, if there is a guilty plea they want to use against the accused, okay, in relation to the same complainant. If there is, Your Honor, there's a history of, violence that, he's not charged with, but we want to go there. I did have an application not too long ago, I think sometime 2 years ago or something, in which the Crown wanted to talk about all these other bad acts that a witness had allegedly observed, which involved the complainant as well. And I'm scratching my head there, and I'm like, well, it has nothing to do with the sex assault, whether or not this person was sexually assaulted, the complainant. Second of all, why do we need a third person to come and testify to what they've observed?
Right. So that's more formally done, but it also happens informally on the fly, right? Where a Crown tries to ask the question they shouldn't.
Oh,
right?
it happens a lot. It happens
Give
a lot.
us some
Sometimes,
examples.
sometimes you will see questions being, and it could be totally innocent. It's not necessarily that the Crown is thinking, haha, I want
Yeah,
to do
I'm gonna
this.
get you,
I'm
yeah.
being sneaky. No, sometimes it just happens that you're in the moment and you're going with the cross-examination, and you're going with the flow, and something.
I'm going to get in trouble from that lady who said that I interrupt you too much during these things. Sorry, if you're watching, it's purely unintentional. Tell her, okay? I know, we know who you are. You said that you had a recent one where they tried to bring in immigration-related potential offenses or something.
It sounded
on the fly.
like it sounded like that's where the Crown was going. So my client was being questioned about his immigration status and how he was sponsoring the complainant and how she was dependent on him. And I'm not an immigration lawyer. I have limited knowledge about immigration law, and I know of how things work. At least I cannot advise anyone on it, but it just sounded like, when you're making, putting questions about you were supposed to support her, you were supposed to do this, you did not do that, and she was on by herself. Well, with the basic knowledge that I have, I'm like, okay, are you going towards an uncharged offense of, you're committing immigration fraud?
Right.
And second of all, that you were supposed to take care of her and you're not taking care of her. You officially promised, or rather acknowledged, that you would take care of her and you didn't support her. So my radar just goes off, and I'm like, no, I'm going to object to this because I think you're going into bad character evidence without hearing much into where you're going.
Right. And that's something you do on the fly, obviously.
Right, exactly. You don't know sometimes, right?
So circling back, just to use that phrase, you've been at the receiving end of a Crown application to get this type of evidence in. How do you compare that experience with what you saw here?
Oh, this is a bit
like,
isn't
this
too
is
much.
like a shit show.
This is a bit too much. Like I'm actually very surprised with the scope of how far it went. One of the things that the Court of Appeals says here is that, all these three women who were talking about these uncharged offenses, the point of bringing this one of the jury instructions was that
I was going to ask you about that. Sorry for interrupting.
So the judge the judge basically, when you're done with the case, the judge provides jury instructions, and one of the jury instructions that the court gave was, you're going to take this not for propensity value, that, just because, they're alleging he did this.
Read what he said, or she said. Was it he, I think?
Was it page 11?
I think
it
so.
was page
11, what the judge said to the jury.
So, bear with me, 5-6 lines.
Yeah. It's important, I think.
The trial court instructed the jury that this evidence must not be considered for the purpose of proving that the defendant had a propensity or predisposition to commit the crimes charged. Like, just because this happened, he's likely to do it. Or just because this one person is saying so, he's most likely to have done what this complainant is saying. The other was that the prosecution introduced these witnesses to the jurors for their consideration on question of whether the defendant intended to engage in the sexual acts intended, and whether each of the complaining witnesses consented. These two things are very important. And the final charge to the jury was that the reason why this evidence was offered was for its consideration on issues of forcible compulsion and lack of consent. Now, if you are bringing these three witnesses to come and testify that we did not consent, and you're trying to use that to show that, Your Honor, maybe,
there's a pattern.
There's a pattern based on what this person is saying. There was clearly some intent, and there was clearly no consent. The Court of Appeal went on to say that, well, when you have three individuals who are saying that they were forcibly, forced,
Forcibly
forced, and then they're resisting it. Well, there is no concept of like maybe they consented, because there is no universe in which you can perhaps say that, the fact that they may have consented, the fact that it's being so violently, and they're saying no, there is no scope of consent. So I don't know how it was allowed. The very notion that maybe we should allow these three witnesses to testify and take no consent from what they're saying and apply to what these complainants have alleged.
And I could potentially see it in a judge alone trial, Like, I think juries normally do a great
It's dangerous
job.
in front of a jury.
But that's what I mean. Like, this stuff going in front of a jury, it's hard to
How do you
extract, dissect,
keep
carve
yourself-
out. Like,
Yeah.
a judge can do it. Juries, I know they try their best, but come on, this 28.
I would feel
pieces of
scared
garbage
when I have so much evidence being allowed to go before a jury, and no.
Well, no wonder he didn't testify, obviously.
There was a news article which said that he was literally begging his lawyers that I do want to testify, but you're opening yourself to a can of worm, a floodgate of whatnot can happen should you testify and get cross-examined on
Whether you
80% of most of this
right.
that has nothing to do with whether or not he sexually assaulted the
Well, that's what
complainants.
Elizabeth Loftus commented on one of our previous
Right.
episodes. What did she say, Max, again? Something a bad thing. The fact that you did other bad things doesn't mean you did this bad thing. We're going to have her back, by the way. She's a really good guest. But yeah, like a jury, that's a lot.
But that's what propensity evidence is, right? Just because you did that, you're more likely
Right,
to have
right.
done this.
Right.
So, which is inadmissible in court.
Right.
So you can't go there.
So, retrial, how do you see that playing out?
It depends on the new district attorney. I think there's a new person who is in charge now, and he has to make a decision whether or not he wants to retry. If he wants to retry, then I think the prosecution goes ahead.
Yeah, but again, if he's going to he may have a fairer playing field this go around. He may actually testify this time around because all this other stuff's not going in. Right. So it may actually be like a normal fair trial as opposed to let's crucify Harvey trial that took place.
Yeah, it's pretty bad because I mean, think about it this way: like you have this one person, and it happened in his case. The precedent that it sets, like let's say if the Court of Appeal did not overturn this,
Oh my God,
did not
floodgates.
did not say that this was wrong, there was an error. Imagine what would happen with the rest of the other cases of every other daily ordinary person,
So just to re-explain it, so in what circumstances in the States would this stuff go in?
What do you mean?
Would this evidence be okay? Like what type of evidence, if you were to give an example, would be okay?
It kind of depends. It totally depends on the state law. So criminal law is very specific.
Well, let's use New York. We've read the judgment.
Right. It kind of depends on the state as well. And you have to, first of all, fulfill the elements of what the test is, right? Is it probative? You have to explain, if there is a probative value. If it's prejudicial, I mean, as a defense counsel, I'm always going to object that it has no, it's prejudicial. Any bad act is prejudicial against my client. Yeah. It's the Crown's job to prove whether or not there's any value or probative value.
So what's an example of something that could theoretically go in your mind?
In this?
Yeah.
Kind of depends. I don't know if he's had an interaction with one of these women before. On this incident he did this and then that happened. I mean, I don't know. I think it comes down to the judge at the end of the day. I, as defense counsel, what is my job? My job is to defend against the charges in front of the court. If I hear you blabber as a witness about stuff that is not before the court, I am objecting. I'm sorry.
Right. Well, you don't even have to say I'm sorry.
And I'm not even, it's not my job to bring a prior discreditable conduct application. It's the prosecution's job. So I don't know in what universe. I mean, there are certain exceptions, like if you want to prove motive and common, scheme, there are certain exceptions. So if there's no like black and white, of course not. It's kind of gray, even though it's character evidence and propensity evidence not admissible in court. There are certain exceptions to it as well. That except if I'm trying to prove narrative purposes, Your Honor, or if I'm trying to introduce it for to rebut what the defendant is testifying to, or something to that effect. Every state has different elements.
No. Have you had any cases where the Crown's been successful in getting stuff in that you're scratching your head?
I think it was only in one case, and that was in relation to a guilty plea, but that was only in relation to the complainant. So the same complainant previously, and I was not the defense counsel there, I was the defense counsel here. In this trial, the Crown is like, I want to be able to, to talk about the prior incident or whatever, or maybe, make submissions in relation to that, Your Honor, and about what happened with the same complainant 10 years ago.
But that was not a trial. That was After a finding of guilt? When was that? Or what stage of the case was that?
This is well before the trial.
Well before.
These pre-trials, so these applications have to be brought well before the
Right.
trial.
That's what I want people to understand.
Right.
This
Well
doesn't-
before the trial. It's like playing, level the playing field, lay of the land. What can you do? What can you not do? In
Right.
and that's in every jurisdiction, even the U.S.
Right.
You gotta bring the
Well,
applications.
Harvey Weinstein's were pretrial motions too.
Right. Exactly.
Right.
So it's not part of the trial. You have to discuss this and get your permissions with the judge beforehand, and then you can do what you want to do within the bounds of what you've been allowed to do
Right.
at trial. One thing that I do want to talk about very briefly is like people. There is a lot of online, outbursts about like, oh my God, like why the hell did this happen?
Oh, don't get
Like,
me started. I was listening to
No.
CBC earlier this week. The outcry is like insane.
No, you.
I get it.
Exactly, you get it because to the normal layperson, you're like, why?
Right,
This
yeah.
is a predator. Why the hell is this
Right.
happening? But there are certain procedures in law. There are certain. I always say it this way: like if this was your brother, your husband, your father, you would probably think differently.
Or you.
or you would probably think differently. But the other part of it is as well that people have to understand is that he is already convicted. Sorry, he's not, or is he?
In another jurisdiction.
In another jurisdiction in California.
Yeah, he's already
So, and
serving
he
a
has to-
16-year sentence there.
Not yet. So he's in New York.
Right.
He was doing his 20 to 25 years in New York.
Right.
Then this news came after New York
They
gets done. He's
transferred-
supposed to
yeah.
go to California.
Right.
So California, he's still a convicted,
Right.
person. So that conviction still stands. But there are rules and bounds for a reason. But things
Yeah.
like this that doesn't happen.
People don't like rules, I find, until they apply to them. Then all of a sudden it's not fair. Why are you talking about what I threatened to cut off? That's not fair. That's got nothing to do with my case. Stuff like that. No, come on.
No, I see your point.
No, when I was listening to the CBC program, I was just listening to, I was so tempted to call in and say something inappropriate, but I didn't. But these people were like ranting about what a setback this is to the victims movement and Me Too. And I said, what's the setback? Is a fair trial a setback? Like, come on.
See, you.
I guess fairness is...
I'll play devil's advocate when I always
you are
like
wearing
playing
red,
the devil's
so
advocate
do it.
with
Yeah,
that,
do it,
the
yeah, do it.
horns. There are different emotions at play.
Of course.
Okay, so we gotta be respectful of all sides. There are people who don't understand the process, the procedure, but at the same time, we have rules and regulations for a reason. You have the right to a fair trial for a reason,
Right.
right? And that way you can lock up everyone and just put them in jail if you wanted to, just because you wanted to, right? Because you don't.
Sounded like that on the program I was listening to. It was pretty scary. It was pretty scary, the opinions that were coming out. Like, people just forget fairness all of a sudden when it comes to this stuff.
But it's also lack of knowledge. That's why we have podcasts
You're
like
far
these,
too
because
generous.
people don't have the podcasts.
These
and
were
knowledge.
literate people being interviewed, but it was kind of
To
scary.
each their own. Let's agree to disagree and call this
Call this an
a good-
episode?
a good way to end this episode.
All right, you be the devil's advocate. When I listen,
Oh no, I see all sides. You got to think about it from both sides. I'm not going to give to one person necessarily, but the right to a fair trial is very important to an accused us as defense lawyers.
all I expect people to be is to be fair and open-minded. Okay, that's
You
all.
would expect that, but not everybody is like
Well, I
that.
know that.
We'd all be happy if everybody was like
Right.
that. Right.
So I guess now we can look forward to Me Too 3.0, whatever 2.0, whatever that's going to look like. Hopefully it'll be a fairer process for everyone involved. Okay, so pillow, ready?
Oh yes, we have the
You gotta do the
pillow.
pillow. Do you have the pillow?
Don't forget to donate.
Donate. No, we're not
always
there
say
yet.
that.
I know you always say that.
Don't forget to.
Just like, comment, subscribe, and share.
Yes.
Thanks, folks. We'll try to get Elizabeth Loftus back to discuss this more because I think it's an interesting topic, and I'm sure Joe will be discussing it in the very near future.
See you.